Hello and welcome to Module 2 of Estate and Probate Management. In this module, we shall be looking at the do's and don'ts in estate and probate management, which is a guide to ethical and professional administration of estate. The module content that we should be looking at here include professional do's, that is the documentation, communication, and ethical practice. Then the critical don'ts, which include asset diversion, conflict of interest, delay, and unauthorized action. Then practical case studies of successful and failures in estate and probate management. We'll also look at practical checklists for daily operation, ethical consideration, and fiduciary responsibility. We'll now look at advanced risk management and mitigation strategies, as well as legal liabilities of executors and administrators, before we now draw our conclusion. Let us begin with the introduction. A position of sacred trust. Estate administration is a highly sensitive, legal regulated responsibility. Executors and administrators are fiduciary, legally and ethically bound to act in the best interest of others. Mistake or misconduct can lead to litigation, financial loss, reputational damage, and criminal liability. Therefore, this model provides a roadmap for professional conduct, that is the essential do's and the critical don'ts. Let us look at the three pillars of professional do's. That is building a successful administration. Professional estate practice rests on these three foundational pillars. One, proper documentation. If it is not documented, it is difficult to defend. So when a property is not well documented, it will be difficult to defend in the law court. Then effective communication. Silence breeds suspicion and conflict. So when you fail to communicate to the beneficiaries, it will breed to suspicion and then conflict may arise. Then ethical practice. Integrity guides every decision. Mastery of these three pillars ensure transparency, compliance, and trust. Therefore, the professional do's in details include: 1. Proper documentation. Documentation is the essential structural backbone of estate management. Essential documents include foundational, that is the death certificate and the original will. So, number 2, probate, that is the probate, grant of probate, as well as letter of administration and oath of executor. Then financial documents include bank statement, debt schedules, and estate account record. Then the distribution, beneficiary acknowledgement form, final account. The best practice here include maintain a structured and secured estate file for all record. Then the professional do in details. Number 2, effective communication. Poor communication is a leading causes of estate dispute. Therefore, the key principle include: 1. Timeliness. Provide a regular update. Delay information creates anxiety. 2. Clarity. Explain all procedures, timeliness, and legal requirements clearly. Number 3. Neutrality. Remain impartial. Do not show favoritism to any party involved. Then documentation. Keep written document of all meetings and correspondence. Another professional do's in detail is number 3, ethical practice. As a fiduciary, your core duties are: 1. Loyalty. Prioritize the estate interest above your own. 2. Impartiality. Treat all beneficiaries fairly. 3. Accountability. Be ready to justify every financial decision. Then number 4, the last, confidentiality. Protect sensitive family and financial information. So these are the professional dues in estate and probate management. Then the 4 critical don'ts, which you must not do as an administrator or executor of an estate, is: 1. This action can lead to disaster. Number 1, asset diversion. Using estate property for personal gain is a no-go area. Number 2, conflict of interest. Letting your personal interest interfere with your duty. Number 3, unreasonable delay. That is failing to act in timely manner. Then number 4, the last, unauthorized action, acting without proper legal authority. These are serious breach of fiduciary duty with severe consequences. Having known that, let us look at the critical don't in more details. Consequences of their breaches: critical don't. Number 1, asset diversion. Example, using fund before probate, selling property for personal benefit. The consequence is very severe. The consequences include personal liability, criminal prosecution, as well as removal. Then number 2, critical don't is conflict of interest. Example, self-dealing, favoring one beneficiary among others. The consequences include nullified transaction, loss of trust, and removal. Then number 3, critical don't is unreasonable delay. Example include failing to apply for probate when somebody died, neglecting asset management. The consequences include financial loss for estate as well as court intervention. Then number 4, critical don't is unauthorized action. Example include distributing assets before paying debt, selling property without authority. The consequences include nullified transaction as well as personal liability. So these are the critical don't, their example as well as their consequences. Having done that, let us look at case studies of successful as well as failed estate and probate management. That is learning from the reality. Case study 1, successful estate. Mr. Okonkwo prompt probate application, comprehensive documentation. So when Mr. Okonkwo died, there is a prompt probate application. So the executor immediately applied for probate. Then comprehension of document, there is a well comprehensive document. Then there is a transparent communication. Then independent asset valuation. Therefore, the outcome is that estate closed within 1 year, no dispute. So in Mr. Okonkwo's case, when Mr. Okonkwo died, there is a prompt probate application in the court. There is a well-detailed documentation. There is a transparent communication between the executor and the beneficiaries. Then the independent asset valuation. Therefore, this leads to a successful one. Then in the case of Mr. Bello's son, which lead to a failed estate, there was a delay of probate for 2 years. Then there was also a poor financial record, secretive and refusal to disclose information, then sold of land without authority. So Mr. Okonkwo's son sold the land immediately his father died without probation. In fact, there was a delay which led to the court removed the son and ordered him to repay the fund to the family. So this is the case of Mr. Bello's son, which led to this is example of failed estate and probate management. Now let us look at the practical tool for daily operation. That is operational checklist for efficiency. Number 1 is daily administration, review task, check correspondence, and update record, and as well as track deadlines. Then assets management, secure all assets, verify titles, monitor income, and ensure insurance. Then probate compliance, confirm legal authority before any transfer, file court documentation. Then financial management, use a separate estate account, record all income and expenses, reconcile regularly. Consistency and structure prevent procedural errors. Having known that, let us look at advanced risk management in estate and probate management. Proactive strategies to protect the estate. Number 1, early risk assessment. Identify potential dispute and complex assets at the outset. Number 2, asset protection. Secure physical assets, freeze unauthorized bank accounts access. Number 3, financial control. Dual authorization for large withdrawals, independent audits. Number 4, legal safeguards. Seek court direction for ambiguous matter. Consult legal counsel. Then number 5, the last, conflict resolution. Use mediation and structured meeting to resolve dispute early. Then let us look at understanding legal liability. That is the personal accountability of fiduciary. Executor and administrator can hold personal personally liable for the following: one, personal liability, which could be ordered by a court to repay losses from mismanagement. So when an executor and administrator fail to perform their duty, it can result to personal liability, which may be ordered by the court to repay losses from mismanagement. Then civil liability, which could be issued by the beneficiary. The beneficiary may sue the executor administrator for breach of trust or negligence. Then criminal liability, which can be prosecuted for fraud. The court may prosecute an executor administrator for fraud, embezzlement, or forgery. Then number four, the last, removal by the court. The court may remove the executor or administrator from office for misconduct, delay, or incompetence. Now let us look at a framework for risk mitigation. That is a five-step process for professional excellence. Number one, identify. Analyze estate size, assets, and beneficiary structure for potential risk. Then number two, evaluate. Determine the likelihood and severity of dispute or losses. Number three, control. Apply documentation, legal safeguard, and financial control. Then monitor. Continuously review administration process progress against the plan. Then number five, the last, document. Record every action to ensure accountability and defendability. In conclusion, let us look at the key takeaway, which is the road to responsible stewardship. The do's include document, communicate, and act ethically, which are the foundation of success. Now, the don't include access diversion, conflict of interest, delay, and unauthorized act, which are paths to failure. Case studies prove that outcomes are determined by professional conduct. Checklists provide the structure needed for daily discipline. Risk management and awareness of legal liabilities are essential for protection. Therefore, the final thought: estate administration is not just a process, it is a professional commitment to integrity, fairness, and responsible stewardship. Thank you and have a nice day.